Okay, it's 12 o'clock, so I say we go ahead and get started. Welcome to Talk to the Experts. This is a three-part educational series, a lunch and learn that we'll be holding for this week and the next 2 weeks. We will be recording these so that you can replay them, or if you were not able to attend, we will be sending this out to those who have pre-registered. We are talking to experts today in the hope of helping special needs families plan under unique circumstances. Our speaker today is Rachel Downs. Next week, we will have Jason Collins, who will be talking about special considerations in a divorce. And I'll be speaking on April 22nd on how to fund a special needs trust. I am Courtney Haycoop with Cloverleaf Wealth Strategies. I am a financial advisor who specializes in working with families who have special needs children or special needs family members. But today, Rachel Downs is going to speak with us. Rachel, you want to go ahead and start by introducing yourself?
Hi, my name is Rachel Downs. Thank you for that introduction. I'm with the law firm of Sevilla Saunders, Huddleston and White. We're a general practice firm here in Leesburg, and my primary practice area is in estate planning with a very particular interest in special needs planning for families or individuals for that matter. And my hope today is to talk about sort of, a broad overview of special needs trusts.
Great. Thank you. And Rachel, you can go ahead and share your screen now. It should let you do that. And for those who are just joining the call, it is recorded. So please keep that in mind if you're asking personal questions and things like that. I will stop the recording prior to the questioning and answer section at the end. Rachel, are you able to share your screen now? Perfect. There we go. All right. I am going to mute myself. Everyone else.
Okay. So as you can see, this is just another introduction at the very beginning here that we'll talk about. And obviously, just to point out, obviously, that today's presentation is not intended to constitute legal or tax advice. However, it's just to provide some intended guidance in a very general discussion. And a no lawyer-client relationship has been established today, but obviously, just to present some information. Okay, so just sort of generally, what is estate planning? And I'm not going to read it in great detail here, but I consider planning that deals with what happens during your life, and certain events happen during your life, which is sort of, we have, you could have children, you could become incapacitated, and then obviously figuring out what to do upon your passing. Part of what we try to address with estate planning is how do we manage legal and financial affairs? If the goal is to minimize taxes, how to address the needs of beneficiaries, whether they be minors or beneficiaries that potentially are incapacitated? How do we deal with the transfer of assets? And this can be accomplished through revocable living trusts, irrevocable trusts, wills, joint ownership, beneficiary designations. Additional documents that accompany estate planning are typically powers of attorney, advanced medical directives. There's also mental health care directives, living wills, HIPAA waivers, funeral instructions, and some people are concerned about the care for their animals. So, we're seeing an increase of that. Letters of intent, those are all part of what we would call estate planning. Now, typically, most people have, some of those folks involved in estate planning, or they're encouraged to get their estate planning through some of these people, but sometimes it could be a financial advisor, a lawyer, insurance agent, family members, accountants, financial institution, a care manager, physicians. They could all be part of our estate planning process. Now, some general questions that I get frequently are, who can make a will? Who should have one? Or, is joint ownership a substitute for doing a will? Other things are, what factors should I consider when I want to make, a will versus a trust? Just what is probate, and why would I even consider doing a trust versus having a will? So just to start, who may make a will or a trust? Well, one, you need to be 18. Two, we need to have the requisite capacity, such as we need to know who our heirs are, which is, if we have a spouse or children or parents, siblings, nieces and nephews, those are considered the heirs. We need to know the contents and extent of our estate. We need to know what we're giving away as part of doing our will. We need to have a desire to execute the will, such that we're not being influenced by someone else to make one. And we need to understand what we're gifting away and what we're making, and the impact of those decisions. We need to have at least 2 witnesses, a notary, and if possible, what we call is a self-proving clause, where you have the notary confirm certain items that when you sign your will about your age, all the items above, age, contents, extent of estate, desire to execute a will, and understanding the directions contained in the will. So who should have a will or a trust, and why? Well, I get a lot of people that come to me and say to me, well, I'll be dead, it won't matter. Well, I can say, when being on the other side of that and helping families with that, it does matter. It does make a difference what you do. You could certainly, by doing nothing, it's a choice, right? But by doing something, we can hopefully ease how to divide the assets and ultimately distribute them. It gives you some control over who is going to be administering the estate, or in the case of a trust for maybe minors or incapacitated people, that you have a say on who that person would be or what entity you chose. A big concern of most families is the guardians. Who are going to take care of my child, my minor children? Maybe we can try to reduce the administrative expenses or specify how we're going to handle the shares for minor beneficiaries. Also planning for someone that may be incapacitated. I think that one of the other things that I get a lot of, particularly with families with children that have disabilities, is that other families members want to make gifts to them or try to coordinate whatever their plan is with whatever the parent is doing. And so we can try to address, people looking to make benefits to those folks. So how long is a will valid? Well, a will is valid until it's revoked, whether it's done, by signing a new document or physical destruction, or if it's lost. Sometimes in a case of a divorce, it doesn't result in a full revocation of estate planning, but certain aspects of the will. Some things that can happen, obviously, with a will also is whether if it was properly executed, or if there's concerns that the person who created the will didn't have enough capacity or were being influenced by someone else. That all can impact how long a will is valid. So what happens if you don't have a will and you're a resident of Virginia? Well, the Code of Virginia has pretty much decided who the heirs are going to be and how they're going to receive the assets. And prior to a beneficiary being under the age of 18, their share would be managed by a person that would be appointed, called a guardian of a minor's estate. And if we have an incapacitated beneficiary, whether they're a minor or an adult, then there would again be someone appointed to manage that share. The consideration in that setting would be that that would become their asset. And in the case but in the case of an adult incapacitated beneficiary, it would become their asset and would be considered a countable resource when dealing with their needs-based public benefits that they may be receiving. So we usually are concerned when folks do not have a will particularly because of the minor or incapacitated beneficiaries, that in many cases people receiving funds outright at a younger age, or if they're receiving benefits, is going to have a significant impact to them. So is a joint ownership a substitute for a will? What about beneficiary designations or payable on death designations? Well, those are extremely important documents. Let's just say that. I would say that I don't think that they're a substitute because they don't enable you to name who is going to control their shares for a minor or incapacitated beneficiary. It doesn't enable you to specify that funds are held for someone for their benefit. It doesn't address what happens if someone were to predecease you. However, they are part of the planning. They are, I get it a lot where someone has come in to see me and they've done these wonderful documents, whether they're a will or in some cases a trust. And then I'll ask them, well, have you funded your documents? Have you completed your beneficiary designations? And many people don't have at all a clue of what they have on record. And then by the time they go back and look, they're like, oh yeah, I did this years ago when I didn't have children or I wasn't married. And all of those factors play into this, as far as, because that is the vehicle, like if you have a retirement account, that is the vehicle that the designation is going to control how that asset is passed. It has nothing to do with what you may have said in your will. Now, if you've gotten divorced, it's extremely important that you go back and review those documents. Sometimes with certain types of assets, that if you have your ex-spouse listed on the document, it's going to be much more cumbersome to deal with that if you pass away. It would certainly be avoided by simply just going and looking at the documents and making the change. The other thing that I see happen is when someone who wasn't married and hasn't updated their beneficiary designations after the fact. I've seen that with regard to people that were divorced, got remarried, never updated their beneficiary designations, and then we come to find out that their ex-spouse is still listed on the designation. So it's not that it's a substitute, but it's a critical component to the estate planning process. I can't emphasize that part enough. So what factors should I consider when making a will or trust? Okay, well, obviously the value of the estate and possible tax consequences. Obviously children from a previous marriage, or minor children, or dealing with incapacitated beneficiaries, or if we've got a surviving, the income needs of a spouse, particularly if you're on a second marriage. We also want to think about, do we want to have some control over who's going to be the executor or trustee or guardian for administering the estate? Are we concerned about having funds held for someone else, whether they be a minor incapacitated beneficiary or just an adult beneficiary that you're concerned about their ability to manage their funds for themselves? So what is probate? Well, this is the process that is a court supervised process where we move the assets out of the deceased person's name over to the designated beneficiary. In some cases, the estate is actually the beneficiary, which means that the executor controls it and then ultimately distributes it to the beneficiaries. It's also the process where creditors can assert their claims against the decedent. Creditors could be IRS, medical care, Medicaid, funeral home, any of those expenses. It's also the proceeding where we deal with will contests, or if there's ambiguity in the documents and where we have the court construe the provisions of the will. So this is the overall idea of probate. So some people ask me, what should I consider in terms of creating a trust? So am I looking to minimize taxes? Am I looking to ease the administration if I have it's accomplishing more than simply what happens at my death. Most of the time, the living trust also deals with what happens when the creator is also incapacitated, whereas a will only speak about what happens after your passing. So special needs planning. So this slide's sort of going to cover just generally what I'm going to talk about here. Obviously, what is a special needs trust? Then I'll talk to you about the different types of special needs trusts that can be created. And then I'll talk about Virginia's ABLE accounts. I'm not going to discuss what other states have enacted, but just the general for Virginia. So what is a special needs trust? Okay, sometimes people call it a special needs trust. Sometimes it's called a supplemental needs trust. This is the type of trust that's created to hold the assets for a disabled person who is or may be eligible to receive needs-based public benefits. The trustee will manage the assets that are owned by the trust, and the trust will be for the benefit of another person. If this trust is properly drafted, the assets of this trust will not be counted as an available resource for means-tested benefits. The funds set aside in a special needs trust will provide for those that are not paid by public benefits. Part of the goal is to be able to provide certain additional comforts to the beneficiary that would not otherwise be covered by those public benefits. And when I refer to public benefits, I'm talking about SSI, Medicaid, Medicare, Veterans Benefits, Section 8, and SSDI, and others. But for purposes of needs-based benefits or means-tested benefits, we're talking about the ones where they're going to count the assets of the beneficiary like SSI and Medicaid. So a third-party special needs trust. So this type of trust is created by the assets of another person. So it is not the disabled beneficiary's assets, it's someone else's assets. It could be a parent, a grandparent, a family friend, aunt, uncle that create the trust. Doesn't have to be necessarily the parent, but it's holding assets of someone else other than the incapacitated beneficiary. Now, it can be created through a revocable trust, or in some cases, an irrevocable trust. It could also be a trust that's created as part of someone's will. I also have people that don't fund these types of trust until the creator has already passed away. Many times we encourage people to create what we call a standalone special needs trust, where it's its own individual document, that it's not one that's created part of the revocable trust or will. This can be particularly helpful when other family members or friends are looking to designate or set aside money for the incapacitated beneficiary. Third-party special needs trust will help to provide guidelines on for the trustee on how to make distributions. And in this type of trust, unlike a first-party trust, the creator can specify who will get the money after the beneficiary passes away. Medicaid is not an automatic beneficiary upon the death of the incapacitated beneficiary. Typically, with the third-party special needs trust, the beneficiary will not be the trustee. The trustee also has to have enough discretion to be able to refuse to make distributions. And for purposes of SSI, the third-party trust must provide that a beneficiary has no authority to revoke the trust, nor can he compel the trustee to make distributions for his benefit. The idea being that the trustee can say no and allow Social Security, rather supplemental security income and Medicaid to pay first. So what's the difference between a first party and a third party trust? Okay, so a first party trust sort of sounds like what it means, which is, in this case, it's the assets and the funds that belong to the disabled individual that contribute to this trust. And this could be assets that the disabled person received from an inheritance, a life insurance payout, personal injury settlement, lump sum payback from the Social Security Administration, a jury decision, income, adult child support, military survivor benefit, alimony, lottery, you name it. This trust can be established by the person who is disabled, their parent, grandparent, a guardian, court ordered, or otherwise it may be provided under Virginia law. Just like a third-party trust, it's to set aside funds to supplement those public benefits and enable them to get disqualification if this first-party trust is properly drafted. Just like a third-party trust, it will provide the trustee on the guidelines on how it is to distribute assets. Now, when the disabled beneficiary passes away, Medicaid is going to be the first beneficiary. So whatever they've paid out on behalf of our disabled beneficiary, they will get paid back first as part of Virginia's estate recovery program. And then if there is many funds remaining in this trust afterwards, after Medicaid is paid back, then it would pass on to the contingent beneficiaries after that. So another option, aside from a regular first party or third party special needs trust, is called a pooled special needs trust. And these are special needs trusts that are created by nonprofit organizations. And the nonprofit organization in that case can either act as the trustee, or they can select another entity or another person to serve as trustee. And with the pooled special needs trust, each individual beneficiary has a separate account. They're called sub-accounts typically. And what they do is that since the nonprofit or the trustee is managing it for multiple beneficiaries that are, disabled, it's all of these sub-accounts are pooled together, and the expenses of having the professional advisor are then spread among all of those respective sub-accounts. And typically, there's very minimal money that has to be contributed. So depending on the particular situation of the beneficiary, these can be a very good alternative, because a lot of times that even if the trust falls below a certain minimal threshold, in some cases down below $10,000, the pooled trust can continue to administer these types of trust efficiently, whereas if we're having a private trustee, that may be more difficult. I've also noticed a trend with pooled special needs trusts that they will also have a third-party version of a special needs trust where the creator can also designate who the beneficiary will be after the disabled beneficiary, as well as the first party. So that does provide some flexibility, and it also provides some professional management and skilled management, because all they focus on are beneficiaries that have disabilities. Typical components to a pooled trust are a master trust agreement. There will be a joinder agreement, a questionnaire, and some other documents that are part of this. But they have, Virginia has pooled trust, but I would probably say probably every state in the United States has one. They may have different nuances to them and different fee structures, but you do have choices. It's not necessarily just one in the state of Virginia, there are several. So ABLE accounts. Well, I like to sort of give them, they are sort of, they were created under a similar act to like a 529 account. They're not a 529 account, but they're similar in the idea that they have some income tax advantages by having these types of accounts. And Virginia was one of the first states to sort of adopt this ABLE savings program. And the way they work is that money that's contributed into the ABLE account, provided that it's less than $100,000, will not be counted or harm the person's receipt of SSI benefits. There's not a limit with regard to the Virginia Medicaid benefits, but with regard to SSI, any amount above the $100,000, it will start to be considered a countable resource. But there are a fairly broad definition of disability expenses that would be allowed to be paid from the ABLE Now account. And as of July of this year, in the case of Virginia residents, when the beneficiary under this account were to pass away, now the Virginia legislation will prohibit the Virginia Medicaid from making its estate recovery against those accounts, which it wasn't in the case. Now, that doesn't necessarily deal with federal Medicaid, but for Virginia Medicaid, they won't be doing the estate recovery now against the ABLE accounts, which is a regard to those. Again, if you don't live in Virginia and you're establishing an account in another state, then you would obviously have to read the rules as it applies there. I'm only discussing the ABLE now for Virginia. These accounts must be established for a person with a disability that arised before the age of 26. So we can't use these for elder adults that now have those benefits. This is for truly the younger child, essentially. There are caps of what you can contribute to them annually, but again, these can be, some people have ABLE Now accounts in conjunction with doing a special needs trust. I had a family that I was dealing with that had not only a first-party special needs trust, a third-party special needs trust, and an ABLE account. They had all three. So it's not an exclusive, it's just one of the different tools that we can use as part of the planning. So a letter of intent. This is a non-binding legal document that is sort of putting together the roadmap that you would use for your beneficiary. And it doesn't have to be just in the case of an incapacitated beneficiary, but what's helpful here is that it provides your trustee with information about the beneficiary, including important contact information. I've seen some where people talk about the activities that they're involved in, medications, things that have worked, can include IEP information, and it's just provides sort of goals. Sometimes people put in there, I want them to participate in these activities and to visit these relatives, and these vacation spots have worked. It's something that you can work on over time. It doesn't have to be, one time at the beginning, but it's certainly very helpful. I know with dealing with the pool trust, the ones that I've seen, they make you complete that as part of the process of setting up the account, that they want to have this letter of intent that gives the details so that they can properly administer that as well for the benefit of the beneficiary. So selection of fiduciaries, particularly when it comes to special needs trust, that is extremely important. I know a lot of people like to pick family and friends to administer these types of trusts for other people, and I will tell you, it really, that person really has to have a very good skill set, or be prepared that they should be able to hire someone to assist them to administer these. I currently administer one now, and fortunate for me, I have the resources to help me between other lawyers, other contacts, a financial advisory team, care managers, and accountants that are equipped to handle these kinds of things. Sometimes people look to have a institution or the pool trust because they have all of those resources at their disposal. It's sort of a trap for the unwary, because it's pretty easy to make a distribution thinking you're doing the right thing, but then you come to find out that, well, no, actually that was accountable distribution, and then that beneficiary's payout in a given month was reduced. It's just sort of a moving target in terms of keeping up with all of the guidelines that are set by Social Security and Medicaid. If you want to have family and friends involved, one thing that we typically see with these types of trusts is sort of what we call a trust advisory committee, where that's where you would put the family members or friends, a physician, and others to help advise the trustee. Another tool we also use is a trust protector, and then that typically would be an independent person who could help serve as an advocate for the beneficiary, but also look over the shoulder of the trustee. Sometimes we give them the power to remove and replace a trustee if necessary, and in limited cases modify the provisions of a special needs trust if there's changes in the law or changes with regard to the particular beneficiary. So it can be pretty helpful because otherwise it's going to involve going back to court and asking either for the removal of that fiduciary and or modification of the trust, which typically would be more expensive and a lot of delay. So with regard to special needs trusts and divorce, I know that we have another presenter that's going to deal with this on a much more deep dive. But with regard to this, what I've seen with special needs trust, divorce is fairly common among families that have children with disabilities. And what I would hope to encourage with folks with regard to this is that they become more educated and mindful as they're navigating the divorce process, particularly as it pertains to child support payments that are going to continue after the child turns 18 and becomes eligible to start to receive SSI benefits, because child support payments typically is considered an available and countable resource to the child, which would then result in a reduction of the SSI benefits. The other thing that I also see with divorced families is that the spouses don't always, the parents don't always do the best job of coordinating with each other about what they're looking to do for the disabled child. I've had a number of instances where one parent is pretty good about taking the lead and then the other parent doesn't. And then all we come to find out after the fact is that the one parent that was doing everything, that was great and all, but then the other parent has set things up where they're going to get an inheritance outright, or there's going to be some other complicating factor that really undermines what the one parent was doing. And that there needs to be some level of least coordinating with regard to that to make sure that everything kind of works together. It's like what's happening with the left hand, what's happening with the right hand. And discussions with regard to that. So anyway, this concludes my presentation today. And obviously, I'm sure people have questions that I'm available to answer if I can.
Rachel, if you could please unshare so I can put the document back up. Oh, looks like I might have closed it. We are such a small group. If you have a question, just please go ahead and unmute yourself and ask your question. And I will get the screen back up while we do that. It looks like Kimberly has a question. Kimberly, you want to go ahead?
Sure, I have a couple. One of them is what kind of expenses can be paid for out of an Able Now account? Do you want the other questions as well, or you want me to wait?
No,
Why don't you go ahead, can you go ahead and do it? I'll write it down while you're talking.
Sure. So, does the professional fiduciary get paid through the trust? And I guess I have the same question for a trust protector, if they get paid through the trust. Or
Okay.
if there's like a retainer you have to establish and separate from the trust.
Okay.
Okay.
Were those your questions?
Yes, ma'am.
Okay. All right.
I can start with the first one, the Able account, because I deal with that a lot. It's really a broad topic for the Able accounts. It's anything that is considered a qualified disability expense is what the words are. So they have some different categories that they list on Able Now. Basic living expenses can be paid through there. So something to think about if a car that is modified specifically for the disabled child is needed, that could be covered. Or if they're unable to transport themselves something such as bus fare or Uber expenses could be covered. Health and wellness, housing, financial management, transportation, education and training, technology, legal fees. Those are all kind of the categories. And it, like I said, it is pretty broad. It's just that it has to specifically relate back to the disability. Is that makes sense for you?
Yes, thank you.
Perfect.
So with regard to the professional fiduciary fees or the trust protector fees, so yes, the trust itself will pay their expenses. As far as having to keep people on retainer in advance, no. Okay. Typically, let me just set aside the pooled trust for the moment. So let's say that you decide you're going to establish your own first party or third party trust. You would typically talk to the person that you're looking to name in that capacity, if it's going to be a professional or an individual, and ask them whether they'd be willing to serve, okay? And then assuming that they did, okay, they don't do anything until such time as that trust is funded, whether it's at your passing or, you know, in the case of other accounts, when the trust itself is funded. And with regard to the trust protector as well, sometimes I have those set up that the trust protector really does not step up until certain events happen, and particularly whether the disabled beneficiary's share is funded, and then they can then serve, or they'll only serve when someone other than a family member or otherwise is in place as trustees. So that can be tailored to the particular circumstances, but the good news is no, you shouldn't have to contribute upfront or hold that position in place. I know with pooled trusts, you have some options where you can go ahead and fund those types of trusts with seed money, and it's very de minimis, and versus just paying a smaller annual maintenance fee when the trust is just going to be funded at a later time. But either of those scenarios, it's not expensive as far as having the trustee involved.
Okay, I guess I have a follow-up question to that then. So if you had a friend who was good with finances that you were planning to make guardian of your special needs child should you pass away, and you designated them trustee and they were comfortable with that, but you wanted a trust protector just in case they needed guidance on the impact of payouts to benefits, or should that person die unexpectedly and you needed another trustee or guardian. Like I guess I'm not quite sure the role of the trust protector should the trustee no longer be able to manage the trust.
So let's say the scenario you just described, right? Which is there's an issue with the trustee because they've resigned or they can't no longer serve. I have drafted them essentially where if the creator of the trust hasn't already named a successor, that trust protector also has the power to name a successor trustee. So they're kind of off in the wings, kind of either to do the appointing of a successor trustee or removal, okay? But they also can be there to look at the accountings every year that are done on behalf of the incapacitated beneficiary, or make suggestions in terms of, you know, entitlements or making changes on the investment strategy. So they are, you know, it's like having someone off on the side taking a look associated with that. And because it's a long-term trust in terms of the beneficiary, it's usually for their lifetime, right? That it's nice to have somebody over there that is sort of not, you know, that they're sort of looking over the shoulder of the other person. Does that make sense?
Yeah, that makes sense. I guess one more question. It's like each piece of knowledge sparks another question. If the incapacitated person dies, what happens to the trust?
Well, it depends on the type of trust.
Oh.
So if it's a third party trust, okay, that's
What I was thinking, third party special needs
right.
trust.
If we're talking about a third party special needs trust, typically when that trust was created using money that was not the disabled beneficiary's money, okay, that creator then can select who the remainder, we call it a remainder beneficiary is, okay? And that could be other children, other family members, a charity, any number of options, okay? The trustee then would basically administer the trust, and we call it a wrap up, right? They would make sure that the last taxes, certain expenses were paid, and then figure out who they were distributing to, who was that remainder beneficiary that they're going to pay out to. So that's what would happen.
Okay, thank you.
I think Melody had a question as well. Go ahead, Melody.
I have a question on the Able Now account. You said in July of this year,
July of 2020. July of 2020.
you're not going to have to pay back Medicaid as beneficiary?
It is Virginia. It's the Virginia Medicaid cannot pursue the estate recovery. That does not mean federal. That's Virginia Medicaid cannot pursue the estate recovery after the beneficiary dies.
That's good to know. That's actually great news.
Mm-hmm. Yep. That was a big drawback. I'm sure people thought about those accounts if it could just still be a Medicaid payback.
Well, that's what was holding me back from getting the Able Now.
That's July of this year, but keep in mind, if you establish an account in another state, different rules.
Yeah, it would be Virginia.
Yeah, it has to be a Virginia account. And again, we're talking about Virginia Medicaid as of July 2020.
And you can establish the ABLE accounts in the state of Virginia in two ways. You can establish that through ABLE Now online, or you can also use an advisor like such as myself or any other financial advisor in the state of Virginia to set that up through American Funds, which is the same company that handles the 529 plans for the state of Virginia. So if you have other kids that you're setting up 529 plans, and you want to set up an ABLE Now for your disabled child, you can coordinate all of those kind of in the same place and not have to deal with two separate entities.
Okay, that's good. Good to know.
Mm-hmm. Are there any other questions you all have?
I'm good.
Okay. Well, I thank you, Rachel, for all of the information you imparted with us today. I'm sure as it all sinks in with all of us, more questions will come up. So you will receive an email from me today with everyone's contact information if you want to reach out to Rachel specifically. This same time next week, we will be hearing from Jason Collins at Daisy Collins Attorneys at Law, and he will, like Rachel mentioned briefly, talk a little bit more in depth about the effects of divorce in the special needs families and kind of things to think about, precautions to take. And just some different scenarios and how that can play out and affect you. And then the following one, April 22nd, same time, I will be presenting on different ways that you can fund a special needs trust. As Rachel talked today, a lot of the funding is done through estate planning. But that is not the only way in which we want to plan on funding a trust, right? We might not know how much of our personal estate will be left, if there will be enough after taking care of us in our elder years to then take care of our special needs child. So I have some different strategies we can employ there, as well as just kind of talking about some overall financial advice and planning strategies. And that'll be on the 22nd. And if you've already registered, your registration goes through for all 3 events. So we will send out a reminder for those as well. If, oh, I'm getting an alert here. Looks like there's one in the chat. Let me see if that's an extra question. Oh, no, it was just a thank you. But thank you all for coming today. And I'm going to go ahead and end our